Hi, I'm Mahesh Jhawar and I'm a chartered accountant and I'm starting this series of videos on latest updates and notifications so that I keep the business people updated about the various circulars, notifications and the latest key changes or some useful information for the businesses. Today, I'll be discussing on the latest circular number 6 that has been issued by the Central Board of Direct Taxes. And this is specifically for those who must have received the notices of default at the time of filing TDS returns, stating that the TDS has not been deducted at the higher rate because of the non-linkage of the Aadhaar card and the PAN card. This circular is likely be going to be a benefit to those taxpayers who must have received the default because government intends to quash those defaults that have been received on satisfaction of certain conditions. So let us look at this circular with the help of the document in itself. Yeah. So now let's look at the circular. So this is the circular that we were talking about, circular number 6 bar 2024 that was issued by CBDT, Central Board of Direct Taxes, on 23rd of April 2024. Okay, so this was the circular that was issued by the authorities, which came in to modify the hardship that was being caused to the various taxpayers. So let me give you a background. What was the actual challenge that was being faced by the taxpayers? So the taxpayers, they deducted the TDS under the provisions of Income Tax Act 1961. However, it so happened that the Aadhaar card and the PAN card of the deductee. Okay, so many of the assessees, they failed to deduct, they failed to link their Aadhaar card and the PAN card. Now, what happened is that when the assessees were trying to file their TDS returns, they were not given the option to check whether Aadhaar card and the PAN card was actually linked or not. Why? Because in many instances, the Aadhaar and PAN card, even though it is not linked, it was showing as operative status when they're filing the TDS returns. And wherever it is inoperative, of course, the assessees have taken the necessary steps and they have ensured the compliance with the necessary section. That necessary section stands for 206 AA. So now, when this came to the limelight, many of the assessees, they started getting notices from the department stating that they have not complied. However, they did not have any evidence, nor they had any methodology of verifying whether Aadhaar and the PAN card of the deductee has been linked or not. So CBDT understood this, and on 23rd of April 2024, they came up with this particular circular. So now, as per the paragraph 4, so you can just remember this is para. From this, the para 4 of this circular, okay, is going to give the relief. Now, what is that relief? Let's just have a look at it. So let me come to the para number 4. So when you come to the para number 4 here, now here it says, let me read this for you. With a view to redressing the grievances faced by the deductors or the collectors, the board, okay, in partial modification and in continuation of the circular number 3, hereby specifies that for the transaction, now here is the importance that you have to pay for the transactions entered into up to 31st March 2024 only. This is what you have to pay attention to. The relief is been given only for those transactions that have been entered into up to 31st March 2024 only. And please go and read this. He's saying, and again, condition in cases where the pan becomes operative, okay, it should become operative as a result of linkage with the Aadhaar card on or before 31st May 2024. So now what is that you have to ensure, my dear? See, all the transactions that have taken place before 31st March 2024, only those transactions, okay, where the assessee is now going to link their Aadhaar card, okay, they are going to link their Aadhaar card with the PAN card, okay, on or before 31st of May 2024. Only for those kind of the transactions, all the default under section 206 AA will be quashed. Okay, so let's say there are certain transactions after 1st April 2024 onwards, then in such cases 206 AA has to be complied with, and the benefit of this circular is not available. Is that clear? So this is the crisp of the particular circular that we are looking for. Thank you so much. I hope you find this video useful.